Hi all, welcome to the A-Level Law Essay channel. This is a specially requested episode by one of the viewers. In this episode, the essay is going to be covering the chapter Negligence in the Tort Law syllabus, and more specifically regarding breach, causation, and novus actus interveniens. Before we begin, please subscribe to my channel for more video guides on essay writing and many other interesting topics. And if you are a subscriber and regular viewer of my videos, thank you. I would appreciate it if you do like and share my videos with your friends so that they can benefit from my remote guidance as well. Thanks. With that said, let's get started with part 1, content guide or video tutorial number 10. Question. The question reads, Alan was employed by Barry's Construction Company Limited. His job involves handling a lot of chemical substances, and he usually does so without wearing any safety gloves as his employer doesn't provide them to their workers. One day, whilst unloading a barrel of hot substance from a lorry, some of it spilled onto his hands and it burned his skin away. In agony, he was immediately taken to a nearby hospital in an ambulance. There, he was examined by a doctor on duty who, after a quick diagnosis, applied some ointment onto his burnt flesh. After that, Alan was given painkillers and left to await further attention. Unbeknownst to any of the hospital staff, the painkillers had a violent effect on him due to the ointment applied to his hands, and because of this, his hands had to be amputated to save his life. Alan now wishes to sue for compensation for losing both his hands. Advise him as to the potential liability of both his employer and the hospital. To answer a scenario-based problem question, it is important to first identify the relevant parties and the issues that they are having with each other. From the scenario, we know that the disputing parties are Alan against Barry's Construction Company Limited and the nearby hospital. Alan works for Barry's, and because he wasn't provided with safety gloves and due to some assumed mishandling of hot substances, Alan's hands were burnt. After being taken to the hospital for treatment, another apparent misfortune befell Alan again and he was medically mistreated, and so he ended up with both his hands amputated. Now we are to advise Alan, who intends to sue both his employer and the hospital. After identifying these important things, we should then be able to figure out which chapter in the tort law syllabus this question is covering. By the looks of some of the key points in the scenario, it is safe to say that it covers the chapter negligence and that it focuses on the topic breach and causation, as we have to determine if either the employer or the hospital have breached their duties of care and caused the eventual damage. Introduction. As this is a tort law question, we should begin by explaining tort and how negligence is the most common kind of civil wrong that can happen under tort law. Briefly define general negligence and list the requirements for negligence to be established. After a brief definition of negligence, we should highlight the facts and the issue within the facts briefly. The thesis statement should state that we will first consider the existence of a duty of care towards Alan before determining if either the employer or the hospital has breached that duty of care and caused the eventual damage. Point 1. Duty of care. Although, for a problem-based scenario question, there is usually no problem with establishing duty of care, but we should definitely go through it as it is the first step in proving negligence. Here, we should briefly define duty of care as a concept which ensures that everyone exercises their civil duty not to be careless in their daily activities. As this is a problem-based scenario question, we should leave out the historical development of the concept of duty of care and go straight into highlighting the modern test to establish duty of care under the case of Caffaro v. Dickman, 1990. The three requirements under Caffaro's test should be briefly highlighted, namely the principle of reasonable foreseeability under Donohue v. Stevenson, 1932, the test of proximity under Muirhead v. Industrial Tank Specialties, 1985, and what it means by justice and reasonableness to impose a duty of care. After highlighting the main principles, we should state that applying these tests into the scenario shouldn't be a problem to establish that both the employer and the hospital owes Alan a duty of care. I will briefly explain this in part 2 of the video guide when I go through the sample essay with you. Generally, the discussion of duty of care must inevitably conclude with there being a duty of care towards Alan imposed on both the employer and the hospital. This is because if we do not assume the satisfaction of duty of care, the answer will not be able to proceed further. Point 2. Alan versus Barry's Construction Company Limited. After establishing that both the employer and the hospital owes Alan a duty of care, we need to further establish if either of them has breached that duty and then eventually caused the damage suffered by Alan. To start off, we will first consider the position of Barry's Construction Company Limited and whether, as Alan's employer, has breached its duty of care towards him. Here, we start off by briefly defining breach of duty of care as the defendant falling below the reasonable standard of behavior expected in someone undertaking the activity concerned. We can use the case of Nettleship versus Weston 1971 to show the objectivity of this standard, and the case of Simmons versus Isle of Wight Council 2003 to show what it means by reasonable standard. After discussing the legal principles of the breach of duty of care, we should now highlight the relevant facts of the scenario pertaining to Barry's breach of its duty of care. On the facts, can we say that by not providing safety gloves to the workers, including Alan, is reasonable care taken by Barry's in conducting the relevant activity? The standard of reasonableness expected would depend on a number of factors that might arise from a situation which should be balanced against each other. The relevant factors here are the size and practicality of protection against that risk and the common practice in particular activities. The size and the practicality of protection against risk refers to the fact that safety gloves were not provided to Alan. Cases that we should consider mentioning are Bolton v. Stone 1951 and Latimer v. AEC 1952. As for common practice, can Barry's argue that the non-provision of safety gloves is a common practice in the industry that it is in? Cases like Thompson v. Smith Ship Repairers Limited 1984 have shown that companies whose industrial practices showed serious disregard for workers' health and safety would not evade liability simply by showing that their approach was common practice in the relevant industry. Therefore, at this point, it is possible for us to conclude that Barry's has breached its duty of care towards Alan when it did not provide safety gloves to Alan. However, the next question is, did Barry's cause the eventual amputation of Alan's hands? Before we go into that, we need to consider the hospital's breach of its duty of care. Point 3. Alan versus the hospital. As we have already thoroughly discussed the legal principles of breach in the previous point, we need not discuss it again here but to go straight into considering the relevant factors in the standard of reasonableness. Here, the special characteristics of the defendant should be highlighted to determine the standard of care required. As it involves medical practice, special skills and professionalism should be discussed to determine the standard of care in a particular practice. The case of Vowles v. Evans 2003 should be mentioned as the defining legal principle regarding special skills and professionals, which states that the degree of care that is legally expected to exercise would depend on his grade and the situation that he is in. Applying this legal principle into the scenario, we now need to consider if the treatment given to Alan by the hospital is up to the reasonable standard required of a medical profession. Questions pertaining to medical practice usually require us to mention the Bolam-Bolito test regarding the standard of practice. The case of Bolam v. Friern Barnett Hospital Management Committee 1957 states that so long as a doctor could find a medical expert prepared to state that the actions complained of were according to the standards approved by a responsible body of medical opinion, the doctor's actions will not be negligent. However, the case of Bolito versus City and Hackney Health Authority 1997 states that it must also be satisfied that the medical expert's opinion was reasonable, in that they had weighed up the risks and benefits and had a logical basis for their conclusion. As no other information is given in the scenario, the conclusion regarding the hospital's breach is open-ended, and it is up to the views and opinions of the writer to decide if the hospital has breached its duty of care. An additional discussion in favor of the hospital can possibly be mentioned, that is regarding the possible novelty of the situation. Due to the situation's novelty, the case of Holt versus Edge 2006 states that as the condition suffered was unusual and novel, misdiagnosis did not mean that the doctor had fallen below the expected standard of his profession. Point 4. Causation. Assuming that both Barry's and the hospital have breached their duty of care towards Alan, we now have to consider if their breaches have led to the eventual damage suffered by Alan. Here, we should start off by mentioning the legal principle under Barnett v. Chelsea and Kensington Hospital Management Committee 1968, which states that the cause of damage must be a cause in fact, i.e., would the damage have occurred but for, or if not for, the breach of that duty? Based on the facts, we can safely assume that both have caused some damage to Alan, but the question is, who ultimately caused the amputation of Alan's hands? This is where we need to discuss the concept of novus actus interveniens, or the new intervening event. This is where, if a new intervening event occurs, making the original damage worse, the chain of causation is said to have broken, and so the original defendant will only be liable for such damage as occurred up to the intervening event. However, where there is an intervening event, but the original tort is still a cause of damage, the defendant remains liable. The case of Baker v. Willoughby 1969 should be mentioned to illustrate the concept. Applying this to the facts of the case, can we say that a hospital has broken the chain of causation when the mistreatment caused Alan to amputate his hands, or would the initial incident have caused his hands to be amputated disregarding? Here, we should give our own views and opinions on the matter so as to come to deciding who is ultimately liable for the eventual damage. Conclusion. The conclusion should be a simple one. The only thing that should be highlighted here is the main legal principle and points of argument which brings us to the conclusion that Alan can successfully sue his employer or the hospital. Review. Before we end, let's have a quick review on the content guide. In the introduction, we briefly defined tort law and negligence, the requirements to establish negligence, and highlighted the facts and issue of the scenario before we moved on to the thesis statement stating our objective for the whole essay. In point 1, we developed our essay by establishing the requirements for a duty of care and applied it to the scenario and concluded that both parties owed Alan a duty of care. In point 2, we endeavored to define and discuss its breach and its legal principles and then apply it to Barry's situation, establishing that due to certain factors, Barry's may have breached its duty of care. In point 3, we consider the hospital's situation and due to certain factors, it may have breached its duty of care as well. In point 4, after establishing that both may have breached their duties of care, we endeavored to consider who has actually caused the eventual damage, while also discussing novus actus interveniens. We concluded it by summing up our discussion and highlighting some of the more important points in the whole content of the answer, and end the essay by stating that Alan may opt to sue either parties. That is the end of the content guide for this video tutorial. If you have any questions or opinions on my approach to answering the question, please do comment below. Do check out part 2 of this video tutorial where I will go through with you a sample essay on this question. I will put a link to it in the description below. If you find this video tutorial useful, please like, share and subscribe to my channel for more. Thank you for watching and I'll see you again next time.